A will is a document prepared by a licensed attorney which provides you the opportunity to control how your property is distributed at your death. If you die without a will, your state will dictate how your property is distributed. You must be of sound mind when your will is signed for it to be considered valid. Once your will is drafted, you're able to change or revoke your will at any time prior to your death. The types of wills accepted by most states are holographic and statutory wills. Holographic wills are wills written by hand. You must sign and date a holographic will and must check with your state to determine if a witness is required in order for your holographic will to be valid. A statutory will is the type of will most people are familiar with. A statutory will is drafted by an attorney and complies with the statutes for wills in your state. A statutory will must be typed or be in writing. It must be signed by you and signed by witnesses. If you're married, you may consider having a reciprocal will where your will is identical to your spouse's will and leaves all assets to the surviving spouse. You may also consider a joint will, which transfers all property you and your spouse own together to a specific individual. When the first spouse dies, the surviving spouse is contractually obligated to dispose of their assets as specified in the joint will. Generally, a will is considered valid when you, the will maker, are a legal adult in your state of residence or are an emancipated minor. You must understand the consequences of writing the will. To confirm that you are of sound mind, you must be able to recognize and recollect the property being disposed of by the will and be able to recognize the relationships of those to whom your assets will be distributed. A will typically includes various clauses, but there are some key clauses we want to highlight. The first key clause is the bequest clause. The bequest clause directs how your property will be distributed and is one of the main purposes for having a will. Another key clause is the residuary clause, which provides instruction on how balances of any assets not distributed through the bequest clause will be distributed. It's sort of like a catch-all for all items that may not fit cleanly within the bequest clause. The residuary clause is also often used to determine how debts and estate taxes are paid at your death. Yes, you have to pay off certain types of debt and pay taxes when you die. If you are a parent, an extremely important clause in your will is the guardianship clause, which allows you to identify who you would want to raise your minor children or any other legal dependents who are currently in your care. For this reason alone, we recommend all parents of minor children have a will. Another key clause is a simultaneous death clause. This clause gives direction on who is considered to have died first if two individuals die in the same event, like a car accident. This is important because who died first sometimes impacts how property is distributed in a will. Alternatively, a survivorship clause typically eliminates the need for a simultaneous death clause. It requires a beneficiary or heir to outlive the willmaker or decedent for a specified period of time to receive the inheritance or bequest. Believe it or not, your heirs may not want the property you plan to leave them. In this case, a disclaimer clause allows your heirs to disclaim, or in other words, turn down a bequest while still allowing your wishes to be carried out. Within the disclaimer clause, you are able to identify who will get the property if the original heir disclaims. For this to be effective, the person disclaiming property must not be able to benefit from the property. In most cases, they also can't come back down the line and attempt to direct who can have the property. They must disclaim the property within 9 months of the decedent's date of death and must do so in writing. Another important clause is the contingent legatee clause. This clause covers scenarios in which the intended heirs die and allows the property that was intended for them to be passed on to their heirs. So if your child dies, your grandchild can receive your child's inheritance. In this case, property can be distributed per capita or per stirpes to the next generation. Per stirpes means grandchildren stand in for their deceased parent and get the share to split among themselves. Per capita by the head means heirs of the same generation get an equal share if they are the only heirs. Per capita at each generation means heirs of the same generation always get an equal share. Finally, To ward off any infighting or legal disputes in relation to your will, a no contest clause is typically used, which significantly decreases or completely eliminates a bequest to an heir if they file a formal legal contest to the will. A will is a critical piece to the estate planning needs of many people. Your financial planner can help you get clarity on all of the assets and property you have. With this information, we highly recommend you meet with an estate planning attorney or utilize the free will resource we have on our website to begin drafting your will today.